Okay, so let me call this case. This is cost number P-37665. This is in the estate of Ramiro Guerra. For those of you that may or may not have a lot of information, I am no longer the presiding judge of the Hidalgo County Probate Court, but I have been assigned this case. I don't remember exactly what the conflict would have been. I don't know that's real relevant, but Judge Garcia, who now presides over this court after my retirement, recused herself. So that's why I'm in this case. Before we start, I guess, let me identify lawyers or parties who have active pleadings for a hearing today by telling me what it is you have before the court.
Yes, Your Honor. Good afternoon. Your Honor, I have a meeting requesting to name a successor executor. If the court recalls, back on April 15th, the court signed an order removing Ms. Gary as executor. I filed an amended request to name the successor executor from the will, Mr. Morales, as the executor. I had originally requested my client, Ms. Guerra, but we were able to make contact with Mr. Morales, and he subsequently hired Mr. McCullough, and we are asking that he be named executor, Your Honor. So that's the pleading for the court.
Okay, Ms. Gary, I believe you also have something pending, is that correct?
Yes.
What did you have pending?
I was trying to get a continuance. We're trying to get a new attorney on our side of it so that we can get it going. We just wanted to get the properties in the estate's name so that we could get it sold and dispersed. But I need a continuance because Mark Talbot jumped off of the case.
Okay, I'll hear you first then, ma'am. I'll ask you to raise your right hand. Will you swear or affirm testimony you're about to give will be the truth?
I'm sorry, can you repeat that?
Will you swear or affirm testimony you're about to give will be the truth?
I do.
All right. Tell me what you think I need to know, and I'll let the lawyers cross-examine you after you have finished.
Okay. Basically, we just want to move forward with the case, get it going. Obviously, it's taken way too long. In the beginning, there was a lot of conflict. We just want to move forward. I would like to get a continuance to get a new attorney going for this. I have an appointment today with another probate attorney to try to get it moving forward. Basically, we just need to sell the properties and be done.
Is that it? Anything else you want to add? Is that it?
Just that I would like to get it done, get it going. It's taken longer than it should have. There was a lot of conflict in the beginning, and then I got frustrated. I won't lie to you about that, and kind of gave up a little bit on it, but I want to finish this and get it over with.
Okay, I'm gonna let the lawyers ask you a few questions, but for my purposes, ma'am, have you sold anything or made any distributions of the estate?
No, I haven't.
Everything is intact.
Right, and I can't sell anything as of right now because it's not in the estate's name.
Okay. Okay, Ms. Alexander, you cross-examine Ms.
Thank you,
Gary.
Your Honor. Ms. Gary, do you reside at 800 North Cayuga Street in Gladwin, Michigan?
Yes.
Are you aware of that?
Ma'am, I don't know why it's coming out garbled. There's this noise that's going on in the background.
I'm sorry.
I don't know where that's coming from, but I'm having a hard time hearing you.
Okay. Not sure. I can speak slowly. Is that any better?
Right now it's okay, but go ahead. I'll stop you again. I'm just telling you there's some kind of garbling going on, a background sound.
Yes, I can hear it too.
Okay.
It might not be you, it might be somebody else. The microphone tends to pick up the other sounds, and so it might be somebody else that maybe they can mute their microphone. I don't know.
Okay. Maybe if Mr. Randall and Ms. Guerra can mute their microphones.
Ms. Gary just muted and the sounds went away, but you're questioning her, so I don't know how we're going to do this.
Yes, maybe she can unmute for her response.
Yeah, I hate to do that, but let's go forward.
Okay, Miss Gary, can you please give us your address?
800 North Cayuga Street, Gladwin, Michigan, 48624.
Okay, are you aware that you have been sent numerous correspondence from the court and from myself in this case to that address?
I've gotten some. The last court hearing, though, I had signed off on by my mother-in-law. I was not home. So that paperwork got shuffled around and I did not know I had the hearing.
Okay. Were you aware that in January of 2019, Mark Talbot was no longer your attorney? He asked to be removed from the case as your attorney?
Yes, I do.
Okay. And how were you made aware of that?
I had gotten a letter. We had tried to get a new attorney. We had found a new attorney. And then due to COVID, things had started getting pushed back. And we'd been trying and trying and trying to get this moving forward. And we weren't getting anywhere.
Okay. Were you aware that Mr. Talbot indicated to the court that he was unable to communicate with you?
I apologize. Can you ask the question again?
Were you aware that Mr. Talbot relayed to the court that he had been unable to get a hold of you and communicate with you?
I did not.
Since Mr. Talbot withdrew from your case over 2 years ago, what have you done in regards to the estate?
Absolutely nothing.
Are you aware that you have a fiduciary duty as the executor of the estate?
Yes.
What efforts have you made to contact Ms. Guerra, Mr. Morales, or any other interested individuals in the estate?
Honestly, not many lately, in a while.
What would you categorize as a while?
It's been a couple years.
Have you made any payments or taxes for any of the properties?
I did in the beginning, not on the properties. I did not, because I honestly didn't know where to pay them.
Was there a safety deposit box in Mr. Guerra's name?
Yes.
Okay, did you gain access to that safety deposit box?
Yes, I did.
Okay, and where are the contents of that safety deposit box?
They're at my home.
Do you have any other property in your possession of the estate?
I do not.
So it's your testimony, the only property you have from Mr. Guerra's estate is the contents of the safety deposit box, is that correct?
That and then the money that we started out with in the beginning, which was about $20,000, and that was it.
Okay, and do you have that in an account in the estate's name?
Correct.
I pass the witness, Your Honor.
Mr. McCullough.
Your Honor, I believe Ms. Anderson covered most of what I might ask, and she has a lot more background on the history of this estate than I do, since I'm just coming into it. So I would defer to her questioning.
All right, I guess if that's all the cross-examination, let me have argument from either. I should ask, do you oppose or do you agree with this request for continuance, Ms. Alexander?
Your Honor, I oppose it. It's a moot point. The court has already removed her, and we're here on, she hasn't filed anything. She's just asking for more time on a matter that has already been resolved. We're here to appoint a successor executor. Your Honor, this isn't a situation where we have the executor who's been missing for a couple of months. Nothing has been done on this case for years. And she so much as admitted it just right now. It's a breach of fiduciary duty, Your Honor, and I ask the court not to allow her any more time or reconsider this matter.
Mr. McCullough.
Your Honor, I concur. My client not only is a member of the family, but he is also a named specific beneficiary of the estate, and all that would have been needed to do to deliver one of the specific bequests to him would be to make the keys available and allow him to come retrieve the vehicle, which has sat idle for the last 5 years. That alone is a breach of her duties to him. Not alone, notwithstanding her duties to her grandmother and other people involved in this estate. And he's prepared to step forward and effectuate the wishes of his grandfather. And this shouldn't take 5 years at all. There's no running business. There's no, these are just assets that need to be distributed. And for that matter, Your Honor, I beg to differ with the witness. The assets don't need to be put into the estate as the executrix, or now as the executor, whoever is the personal representative of the estate can sell the assets without a further step. The court's aware of that as a personal representative of the decedent. So that's a step that I'm really not sure what she means by that. So we're ready to move forward and distribute.
I guess I just looked at one very briefly at the will, and at the point where it says 25% to his wife and 25 to Yvonne, Guerra, Rondell, and 25% to Ramiro, Ricardo Guerra, and 25% to the children of Andrea, Marie Guerra, being Georgiana Claiborne, who I understand to be Miss Gary, and Mason Allingston. Those are kind of the general, I guess, distributions. But your client, and so I was curious whether your client had any, was a beneficiaries. Is that it? The vehicle that you made mention, is that the only thing that Mr. Blaine is a
Well,
beneficiary?
Your Honor, his mother is a deceased child of the decedent. So he stands to as a direct beneficiary through her.
Yvonne, is that his mother, or who is his mom?
Mr. Morales, could you answer that for the court?
Yeah, Yvonne was my mother.
Okay.
Or is my mother.
And by the way, did Miss Yvonne survive this? Her, would that be your grandfather or her father?
That's my grandfather, my mother's father.
Did your mom survive her father?
Yes.
I understand from Mr. The other gentleman that Miss Yvonne has passed. Is that true? Do I remember that correctly?
Yes, Your Honor.
Yes, Your Honor, but he testified that she passed away after her father.
Okay, all right. Okay. Okay, you said it was moved, Ms. Alexander. Maybe I misunderstood, but I understood, well, I interpreted the motion for continuance to be a continuance of the motion to appoint a successor. I guess I was assuming because I have removed already this, as you point out, Ms. Gary as executor on April 15th for my notes. Were you aware of that, Ms. Gary? I signed an order removing you on April 15th.
Okay, no, I was not.
Okay, there's an order that was signed. Send it to your Michigan address. Removing you because we couldn't get you to respond to anything. We didn't know you had moved or what had happened to you. So you are, as it stands right now, not the executive.
Okay.
So it's important for you to know that you, as of April 15th, you no longer have any authority.
Okay.
So what's left is the motion to appoint a successor. When you say a motion for continuance, what was it that you were seeking to have continued?
To try to get going with it again, but I didn't realize I was already moved. So I guess at this point, it really doesn't matter.
Well, that was Ms. Alexander's point. Is that?
Yeah,
you
no.
agree with that?
Yeah.
Okay. All right. So let me take this under advisement for a minute. Let me hear on the motion to appoint a successor. I'll make a ruling for the hearing on the motion to appoint a successor. Is that your motion, Ms. Alexander? Could she proceed, Mr. McCullough, or do you want to do the prove up, or how do y'all want to do that?
It's your motion. If she has any argument, then I would defer to her, and then I'll do the prove up. I've already talked with Mr. Morales about his qualifications, and we can prove that part up.
Okay, then you'll call. Either one of you will call Mr. Morales. I'll ask you to raise your right hand, Mr. Morales.
You'll need to unmute Mr. Morales. There you go.
All right, sir, I'll ask you to raise your right hand. Will you swear or affirm testimony you're about to give will be the truth?
Yes.
Go ahead. Mr. McCullough or Ms. Alexander, whatever, whichever you prefer.
If you want to do the prove up, that's fine, Mr. McCullough.
I'll do that, Your Honor. Ms. Alexander filed the motion to appoint a successor, but the court has already removed Ms. Gary, so, and the will names Mr. Morales as successor. So I'll do some brief prove up on Mr. Morales. And I guess the appropriate thing to do would for me to be ask the court to take judicial notice of all the documents in the court's file, including the history of the case, and that the will has already been admitted and it has already been established that the decedent is in fact deceased, and all of that information is already before the court. So I'll abbreviate my my evidence. Okay.
No objection, Your Honor.
Mr. Notice of all the documents in the case. Go ahead.
Okay. Mr. Morales, for the record, would you state your name?
Blaine Morales.
And are you the same Blaine Morales that is named in the will, the last will and testament of Ramiro Guerra as the successor executor?
Yes, I am.
Okay. And as you heard earlier, and as you advised me when you first called me, your cousin Georgiana has been removed as the primary executor, and you're next in line. Yesterday, you and I spoke about the qualifications for serving as an executor and as a fiduciary, did we not?
We did.
And I advised you of some of the disqualifying factors that would prevent you from serving as a fiduciary for the benefit of your grandmother and other members of your family. And you advised that you did not have any disqualifying history. Is that correct?
Correct.
And you don't have any claims against the estate of your grandfather except as a beneficiary and as a distributee under the terms of the will. Is that right?
Correct.
And you're prepared to serve if the judge sees fit to appoint you. And you have already, by the way, signed an appointment of resident agent, which we filed this morning, and you sent it to me yesterday. We filed it yesterday. You sent it to me yesterday. Is that right?
Yes.
Since you're a citizen or a resident of, I believe, the state of, help me here, Indiana?
Michigan.
Michigan. Okay. So you're an out-of-state resident, and you appointed me as your local resident to assist you with any papers that may be served on the estate. Is that right?
Yes.
Okay. Your Honor, I pass the witness.
Ms. Alexander?
I have no questions, Your Honor.
Chair, do you have any questions for Mr. Morales?
I'm sorry?
Do you have any questions for Mr. Morales?
She's my client, Your Honor, Ms. Guerra.
No, I'm sorry. If I said Ms. Guerra, I meant Ms. Gary.
Oh,
No, I do not. Thank you.
Mr. Morales, have you ever been convicted of a felony?
No, sir.
Have you ever been adjudged to be mentally incompetent?
No.
Okay, could you give me your address? I don't know that we have your address anywhere in the pleadings.
Yep. It's 1770 Short Road,
Short?
Saginaw.
S-H-O-R-T?
Correct. That's Saginaw, Michigan. S-A-G-I-N.
Yeah, I know how to spell Saginaw. What's your zip code?
Okay. 48609.
Okay, Ms. Gary, do you have any objections to my appointment of Mr. Morales as the
No, I do not.
successor executor?
No.
I have one concern. For some reason in the background, I remember maybe it was correspondence between the parties about disputes about a piece of land that had conveyances to Ms. Guerra. Is that the core legal dispute about who owned that land at Mr. Guerra's passing? Do I remember that correctly, or am I maybe confusing the cases?
I don't think so, Your
$1
Honor.
million piece of land or something like that sitting somewhere that needs to be sold.
Oh, there's a piece of land in Waco, I believe. I don't know. I saw that in the original inventory, they valued it at $1 million. But my client doesn't know much about it or how much really the value is. To dispute as to title, that would have to be looked into.
Okay, so Mr. Morales, you don't have any position one way or the other, or you're not even aware that there is a dispute about who owns the land?
I'm having a hard time hearing you, Judge, with that background. Ms. Gary, would you try muting yourself right now so I can see if that clears it up? Thank you.
Right.
Okay, Judge, try again.
That there were some conveyances made that Ms. Gary has even spoke of in her request for a continuance. You don't know anything about that?
Oh, Your Honor, if the court's referring to the email that property was put in my client's name, if that's what the court's referring to, I think perhaps Ms. Gary's confusing like the taxing. My client has been paying all the taxes. And so sometimes the taxing entities will put it in that person's name, but there are no conveyances or anything of that nature. The property will.
So Mr. Morales, we're not aware of any conflict with Mr. Morales that he's going to get in the same dispute with Ms. Guerra as Ms. Gary. There's not that potential.
I don't believe so, Your Honor, no.
Okay. Ms. Gary, you're at a severe disadvantage, but you kind of are responsible for your situation. But I want to take this request under advisement for 10 days. If you don't have an appearance by a lawyer and then any indication that you're going to contest any of this so far, I'm going to grant the application. I do want to give you 10 days. You say you have an appointment today. I may sign it anyway. It just depends on what your lawyer, if you hire a lawyer, number one, and if you do hire one, what they have to say. We're not going to go back to try to start over in 2019. But I do want to give you the benefit of a 10-day. Essentially, what I'm doing is taking the application. You are removed. That stands. I want to take a 10-day, take it under advisement for 10 days to see what you do, what your lawyer does. I can't speak for you or your lawyer. So I'll wait 10 days. But if I don't hear anything persuasive or convincing or something that's cognizable in law, I intend to sign it. Someone needs to have responsibility to start moving the ball. So I'm going to take it under advisement for 10 days and see what happens.
Okay.
Any questions, Mr. McCullough or Ms. Alexander?
Yes, Your Honor, I would like to address the court on one matter. If the court is inclined to appoint Mr. Morales, I would ask that the court include in an order, happy to prepare an order advisor, that the former executor ordered to deliver any assets.
Okay, I'm not hearing anything you're saying, Mr. McCullough.
Okay.
Ms. Gary?
If,
Okay. How about now, Mr. McCullough?
okay, let's try it
We'll try
again.
again.
Okay.
Your Honor, I would ask that the court order Ms. Gary to turn over any assets in her possession to whomever the judge sees fit to appoint as the successor executor, including any bank account information, personal assets. She already testified that she has the contents of the safe deposit box in her possession. And so I would put that in ask the court to allow us to put that in an order if the court's inclined to appoint my client.
I think the order of removing her orders her to turn over assets upon the filing of the oath by the successor, the qualifying by the successor, and that she is also ordered to turn over assets and to relinquish her letters. So that's already in place. If you look in the history of the case and you find my order removing her, I'm trying to verify. And if you're not satisfied, if you want to, it says, is therefore ordered that Georgiana Claiborne Gary be and is removed as executor of the state of Ramiro, Guerra. that the letters issued to him or her be and are hereby canceled of record. Further ordered that Georgiana Claiborne Gary relinquish and deliver all the assets, all of the estate remaining in his hands to any successor upon his or her qualification. So the order signed April 15th has that language in it.
Thank you, Your Honor, and thank you for repeating that on the record in Mrs. Gary's presence, since I'm not sure, she indicated that she hadn't received a copy of the order. I appreciate that, Your Honor.
Ms. Gary and all the other people that are involved in this case, if you have an interest in this case, if you're not aware, I do want to make you aware that Hidalgo County has public access to anyone who has an internet connection. If you look under the county court records, there's a place where you can look for this case number. The case number in this case is P-37665. And you can follow this case, any individual entry in the order that's been signed. The likelihood is that you'll be able to get copies of any orders. If not, if you contact the clerk, I'm sure they'll accommodate you. So everyone that's involved in this case can keep track of this case. These are public records that are available to each of you. So if you've been frustrated by the lack of progress, this is some way for you to keep up to date. Okay, if there's nothing else, I'm going to wait 10 days. I have your proposed order, Ms. Alexander. If you share it with Mr. McCullough.
Actually, Mr. McCullough prepared the order, Your Honor.
Okay, then I don't know why I thought I had received it from you. So, Mr.
Oh, I
McCullough.
may have also, but there may be two of them.
Okay. Well, I have an order that I'm going to sit on for 10 days, and if I don't hear anything that's remotely persuasive to me, I'm going to sign it, and then we'll see what happens next. That's all. Everybody
Your Honor.
all right, that's all. We'll end the proceedings. Y'all have a nice day.
Good to speak to you.
Thank you.
Thank you.
You too.